Good afternoon. My name is Kate Bartlett. I'm the dean here, and I'm absolutely delighted today to introduce my former colleague, William Van Alstyne, as our 39th annual Brainerd Currie lecturer. The Currie Lecture is our most distinguished annual law school lecture honoring Professor Brainerd Currie, professor of law at Duke from 1946 to 49, and then again from 1961 to 65. As one of the most well-known, best-respected, most prolific scholars Duke has ever had, Professor Van Alstyne is quite the perfect choice for a lecture to honor one of the other handful of scholars who are among the most well-known and best-respected that Duke has ever had the honor of hosting as professor. You will hear more about Professor Currie in today's lecture, but I want to note and welcome three members of the Currie family here today. David Currie from the University of Chicago, who is also an extraordinarily well-known and well-respected legal academic. David's wife, Barbara, and his sister, Carolyn. I want to welcome to the Currie family. I will leave you to read the basic biographical data on Professor Van Alstyne from the program. For my introduction, I'd like to read portions of a tribute I wrote for the upcoming Duke Law Journal issue honoring his scholarship. William Van Alstyne is without question one of the most distinguished scholars ever to have taught at Duke Law School. He came to Duke in 1965 from Ohio State University, where he had been a colleague of another future Duke professor and former dean of Duke Law School, Paul Carrington. At Duke, Professor Van Alstyne was an extraordinarily productive constitutional law scholar. He has published widely in the areas of free speech, church and state, academic freedom, state action, affirmative action, due process, presidential impeachment, the Commerce Clause, the constitutional amendment process, the Second Amendment, federalism, and there are more. As Professor Chris Schrader wrote in a Duke Law Magazine feature on Professor Van Alstyne, there are remarkably few scholars working today, and none of them of Bill's stature, who can truly be called students of the entire Constitution as a legal document. Many constitutional law scholars enjoy writing in the area of constitutional theory, which deals with the Constitution at a very high level of abstraction, and many have made a specialty of one aspect of constitutional law, such as freedom of religion or free speech. Bill, on the other hand, has brought an incredibly sharp and discerning mind to many, many different constitutional questions, always showing an enormous respect for the Constitution as written law. I first learned Professor Van Alstyne's name when, as a law student at Bolt Hall, the University of California at Berkeley in the mid-'70s, I was assigned to read his article, The Demise of the Right-Privilege Distinction in American Constitutional Law, published in 1968 in the Harvard Law Review. This article, still required reading in many constitutional law classes, is one of the most cited law review articles ever written. Indeed, in 2000, a study published in the Journal of Legal Studies named Professor Van Alstyne as one of the 50 most frequently cited legal scholars in the United States of all time. Professor Van Alstyne is a scrupulous scholar and a vigorous voice for integrity in scholarship. Reading his work, one cannot help but be impressed that he approaches every legal question without prejudgment or hidden agenda. He wants to get it right every time. His impatience with result-oriented scholarship was legend at Duke, as were his sky-high standards for himself most of all. It was this characteristic that led many judges, lawyers, and academics in a number of polls through the 80s and 90s to believe that Professor Van Alstyne was among the most qualified persons in the United States for appointment to the U.S. Supreme Court. No one is more passionate about the U.S. Constitution. Professor Van Alstyne carries it with him virtually wherever he goes, and like Johnny Appleseed, passes it out whenever the occasion might possibly call for it. Bill has often been called on over the years to put his understanding of the Constitution into action, testifying before congressional committees, filing briefs and arguing cases on matters of constitutional importance, giving advice to those seeking to stay within constitutional boundaries, serving as a member of the National Board of Directors of the American Civil Liberties Union. He is also passionate about matters of academic freedom, having served as president of the American Association of University Professors and acted as informal advisor on numerous faculty and in university administrators' committees at Duke about academic freedom matters. Over his 4 decades at Duke, Professor Van Alstyne was also a remarkable teacher. Decades of students remember his elegant lectures, his challenging Socratic dialogue, and, of course, his motorcycle and leather pants. As I travel the country visiting with alumni, there are few, if any, law faculty about whom Duke graduates most often inquire, still. To innumerable past students, many of whom I'm very glad to see here today, he defined the excitement and intellectual challenge of the Duke Law School classroom. Professor Van Alstyne still sets the record at Duke for the youngest person ever named to a distinguished professorship. Although he moved on to the William and Mary School of Law in 2004, he continues to hold the William R. and Thomas S. Perkins Chair in an emeritus capacity. This was more for Duke's benefit than his. We think of him as a Duke jewel and look for opportunities when we can continue to claim an association with him, as we do today. Professor Van Alstyne.
Wow, I think, friends, it would be best not to speak at all and just leave you with a really good impression. You all have these manila envelopes with this forbidding legend of "do not open," but now you are to open them. But you're not to peek ahead, because this is a progressive talk, actually. And so after about 10 minutes of preliminary monologue, you and I are going to struggle our way through a constitutional problem, the function of which will be to illustrate, at least, the title of this lecture, which is Clashing Visions of a Living Constitution. The topic is more timely than I'd ever anticipated, if just because we have been mutually watching some television channels on the Supreme Court confirmation hearings. And so you can see quite a range of views as to what even senators seem to desire of persons to be appointed to the Supreme Court and how they ought to view their own obligation when they serve on that court. And true to the dean's word, one of the enclosures, and we will be beginning with that very early on, is a souvenir copy in classic Duke blue of the Constitution. Because unlike other approaches sometimes taken to this fretful subject, there is a text in this house, if not in every. There has been a slight dilemma, and it shortens my remarks on the substance of it, though, for me in the following sense, that I want to make some observations about Brainerd Currie and also about Professor David Currie, who has flattered us all by coming with his wife and sister to this event. And it will take about 5 or 6 minutes. I need to do it now for fear that the subject will carry us away, and I cannot do it appropriately at the end. So I do want you to know that this is, in a sense, closing a circle. I came to Duke because of, and on the initiative of, Brainerd Currie. The chance was that when I was still a student at the Stanford Law School, the sole article and book review editor, Brainerd was then in residence nearby at a center called the Center for Advanced Study in the Behavioral Sciences. He was on leave from Chicago, where he'd been teaching for some time, and completing a trilogy of articles in Conflict of Laws, which was then to cement his reputation as the foremost scholar of that field during his lifetime. In fact, in that connection, even after I had prepared these other remarks, and I was reading a very lengthy article in the Texas Law Review less than 2 weeks ago by one of their senior professors, Louise Weinberg, where she goes through what she called the American conflicts revolution of the last 5 decades. She had the following sentence about Brainerd Currie, and it was this one: "Nothing in the intellectual history of the American conflicts revolution was of greater moment than the publication of a law review article some still consider the greatest law review article ever written." Wow. I mean, not the greatest conflicts article, just the greatest law review article ever written. This was one of a trilogy, and that one, alas, appeared in the Chicago Law Review, One of the other two sharing the same subject appeared with us at Stanford, and the third in Columbia. Brainerd went on and became the first recipient ever of the Order of the Coif Award for Distinguished Academic Legal Scholarship. And he was my colleague here, and it was only because I just then completed the course in conflicts as a student, and kind of brimming with excitement. And since Brainerd was nearby and an incredibly cordial person, we had some conversations, and he remembered that fondly enough so that 5 or 6 years later, when Jack Laddie was in search of junior people, at any rate, Brainerd remembered me well enough to have Jack Laddie invite me for a visit, and we were off and running and colleagues for the rest of his time here. The cycle is completed, and this was at the end. You will find in this envelope a stapled part, and the first part is in re Brainerd Currie, and it contains that quotation that I just shared with you. I'm not sure if it's at the beginning of your envelope or at the back. Just behind it, however, it is not the publication litany of Brainerd, which was very substantial. It is rather just the law library's combing through and recollection of the work of his son, David Currie. And that is to complete the circle. I overlapped with David as a visitor at Chicago. And he is near retirement himself now. This is, I would guess, even an incomplete bibliography of David's work. But he is, from my own perspective, the most distinguished scholar in American constitutional law now living, accepting none at all. Not simply in terms of the volume of the work, but in terms of its integrity and its orientation. It's almost without exception that I have yet to read something by David without saying, I didn't know that, without learning something. Whereas with most works, one says, I already knew that, and the parts that seem to be new, I don't agree with at all. They're just... Or as one critic once said of a work, there's much in this work that is new and much that is good, but that which is new is not good, and that which is good is not new. Which is true of other people's work in this field for a variety of reasons, but never with David Currie. He's the unfailing senior scholar in American constitutional law, and I consider it just a wonderful gesture of flattery that he and his wife and sister would attend this event. And I will make that demonstration clear, I think, as we go through this lecture, so that you can see how I picture David himself in the field of constitutional scholarship and what it is to do that kind of scholarship. So I will put that aside and turn to this subject, and perhaps if there are a few moments at the end, come back to it. So the first item in this open envelope, and we're only going to go page by page. If you go and sneak behind pages, it's a form of audience fraud. You must not do that. The top page, in a sense, is a guide to the totality of this presentation. And to the extent then that my forensics fail, it may be that in your private time, as you sort through even the features of that top page very carefully, you'll get the idea of the entire process. At the top of this, I've arbitrarily listed a number of standard nouns. These are perhaps, I didn't even count them, 14 different nouns or words that theoretically describe different approaches that people take to the field of constitutional law, both as academics, but also as judges, as people active on the bench. And I will illustrate only 2 or 3 for fear it would otherwise consume the body of our lecture. But there are at least more than these. In fact, had I gone through the list to the point of tediousness, it would have been at least 20 nouns in length, because a variety of judges and authors with human vanity in mind are always inching for some kind of descriptive phrase that will distinguish themselves from the common herd, and if successful, perhaps provide a new talisman, a new way of describing a whole field, taking it over. I'll touch on only 1 or 2, just because I think they're so remarkable. One of these is called, if you look in the right-hand column, non-interpretivism. Non-interpretivism. This is a suggestion that as you come to this Constitution and you want to make it a living Constitution, it would be false to say that the judge or even the scholar is actually trying to interpret the language or the words that are written there. Because frequently the jurisprudential vision that is the desirable vision for the country to share is very difficult to superimpose on those particular words. It's too great a struggle that would introduce an incredulity. There is a school of thought, however, remarkable as it may seem, that suggests with a living Constitution the text is a subordinate matter, lest we be ruled, as it were, by the dead, an unimaginable thought. But it is nonetheless, and this came out of a famous essay really by Stanford law professor. These are not inconsiderable people whom I will briefly review. Tom Gray, about 20 years ago. And then Michael Perry at Northwestern built up the phrase. But even as you look at the phrase, it's very strange. Non-interpretivism, I take it, means we do not purport even to be interpreting whatever may be written here, albeit we are delivering ourselves of a statement of what constitutes the supreme law of the land. That is to say, something the Constitution authorizes on the part of Congress, even though it may be hard to find words that do so, or forbids to Congress, even though words may fail us, for the function of a living Constitution, again, is to spring more freely than this wooden text. That phrase did not endure, partly, I think, and I take a certain impish responsibility, because I wrote to Tom and to Michael Perry, and then put into a mischievous footnote a question one day, merely asking which part of the Constitution was it that they were non-interpreting that day, since they didn't purport to be interpreting anything at all. And the locution shifted. A different school has been called non-original interpretivism. It's the one that follows. Now, by non-original, it simply means that it does not purport to adhere to what might have been the common understanding linked to the particular clause or phrase, either the clause empowering Congress to do certain limited things or other clauses restricting from doing other things. Again, this is an approach that eschews this mindless historicism, which others tend also to dismiss on grounds that it's an empty inquiry anyway. So it's called non-original interpretivism because you're interpreting language, you are using the particular clauses as a forensic point of departure, but you're not purporting to be ruled by the unreliable, or possibly irresponsible, and always difficult to recover material of the original drafters or ratifiers. I will only pause to note, you'll notice it's called non-original interpretivism, even though that's a lumpish phrase, because the contrast might be, you see, with unoriginal interpretivism. And while that might be more to the point, it's kind of self-defeating. I could go through more, but I won't. These are the outliers. One, on the other hand, that's an outlier I want to point out in the left-hand column. And these aren't arranged politically. I'll get to the political arrangement in just a moment. Are what are called Ackerman amendments. Now, for those of you who are familiar with the field of constitutional law, this will be old stuff. But for those of you who are not, you'll find it interesting. Bruce Ackerman's a very senior and a powerfully well-published person at the Yale faculty. Indeed, is currently in the New York Times, is mounting a substantial campaign within the Yale Law School to defeat the nomination of Judge Alito. Bruce published a work suggesting that the manner in which certain amendments have come to be interpreted, come to be construed, honestly, and certain portions of the original document, honestly do not bear any fair correspondence to any original understanding. It is so far remote from that, and there isn't any actual amendment to record that that has been the change registered by the appropriate requirements of the amendment process as Article 5. So Bruce's is an admission of candor at step 1 and then a claim of bravado at step 2, and that is that there are non-textual amendments. So we call them Ackerman amendments, or as I like to call this school of thought, it's a school of thought that I would call Ackermania. And those who are devoted to it are Ackermaniacs, as it were. But the notion is, apparently, that if through sustained elections, and his best example is the 3- and 4-term service of FDR, the country's attention is riveted on certain crises, and by returning the president who's made a political point that he wants a change in the substance of constitutional law and will seek that through the appointment process. And that seems to meet with the approval of a vast majority of all Americans because of the re-election of the president plus the continuity of the appointments, then quickly approved by the majorities the president has in the Senate. These then serve as, quote, real amendments. And so it would be inappropriate for any later Supreme Court to go back. That they are not moored to the text, that they do not possess the credentials of a genuine amendment, is neither here nor there, because the discovery is made, therefore, this is the way in which you keep a Constitution alive. And the real challenge for the Ackerman amendments is what he describes merely the rule of recognition. How do you know when this has happened, so that subsequent judges are then disentitled ever to go back and renege or abridge any of those changes? And he has certain criteria. But it's very interesting because it's an alternative. That is to say, he suggests that although the provisions in Article 5 that speak of the methods by way of which you change the Constitution would appear to be exclusive, they need not be deemed exclusive. There may be this exogenous political method of seeking change, and when it takes place, judges are expected to respect those changes and to treat the unwritten parts co-equally with the written parts of the Constitution. Now, I'm going to drop this without going all through the rest. Some of these are more mild, as they make finer distinctions. And I used to think that it was just a polycentric universe of sprawling theories, as each academic and judge would attempt to wedge a certain special theory in approaching the Constitution for political favor, hoping it might enjoy a substantial consensus and then become the kind of standard way of viewing the judicial task. And that and I know at least some judges have grown understandably impatient, not merely Harry Edwards, who wrote quite a bracing piece more than a decade ago, asking for more help in approaching constitutional law and less abstruse theories. But just by accident, within the last weekend, I was in Washington on another errand and saw Senior Judge Patricia Wald, not exactly an ultra-conservative. Emerging from some other meeting, we had coffee on the way, and she said the same thing, that she said that the field of constitutional scholarship has now become so pervaded by the sense of philosophic pretension, as it were, and abstract reasoning, that the federal judges only occasionally now turn to academically written articles in the field of constitutional law when uncertain on the fringes. A very interesting remark from Pat Wald, as it were. To shorten this, my own feeling is that you can actually divide the field of all of those in constitutional law, scholars and judges alike, into two groups, not 20 and not 12 and all of a sudden. And I've shown that in this next figure, the so-called obligationists and the opportunists. And I preceded that with a brief quotation from Justice Hugo Black, who had one of the longest tenures in the history of the court until William Douglas surpassed him. It was the longest. So I'll read it to you. He says, "I think most Americans do not understand the Constitution. It is all because each one of them believes the Constitution prohibits that which they think should be prohibited and permits that which they think should be permitted." And you think, well, it sounds good to me. I mean, what the hell do you want? I mean, but that was Black. And it's a very nice quotation from Justice Black. In fact, he said that in the course of a 60-minute interview. That's why it's listed as an interview. Years and years ago, in commemorating his 30th year on the Supreme Court, an interview with Eric Severide and Martin Agronsky, during which he actually held, during that interview in his office, a copy of the Constitution, no bigger than this. It was a darndest thing. And near the end, Severide, who was very well-spoken, quite patrician, and a little bit pompous, said, "Mr. Justice Black, I noticed throughout our conversation you've been fingering a small pamphlet. By chance, is that a copy of the Constitution?" And he says, "Well, yes, Eric, it is. But, Mr. Justice, you've been on the court for 30 years. It's a fairly small document. Surely you know it by now," he said. To which Justice Black picked it up out of the drawer in his hand and started to stroke the pages. And he looked at Eric Severide just beamingly. He said, "Oh, no, Eric," he said. "You'd be surprised how much you can learn just by reading it." Which is behind his quote. They say, Black understands that this is not a perfect document. In fact, those of you who travel or taught abroad, as David Currie has, and I should mention in passing, it's not just that he is the most well-regarded American scholar of constitutional law, but our late colleague here, Herbert Bernstein, who came to us from the Max Planck Institute in Germany, borrowed a volume that I had in my office by David Currie on the German Constitution, brought it back 2 days later, and said, "This is the best work on the German Constitution that's available." That is to say, in English or German. His scholarship was so superb. If you read these other constitutions, they read better. There isn't any doubt. They come closer to the mark, that you would find things in there you think, well, they should be permitted, and you find other restrictions that should be prohibited. Ours is a rather short and somewhat emaciated document, though it has been improved or at least altered from time to time by amendments. But that was his observation. And I would divide the field really in the manner I've done it here, with this overlay of a graphic. The opportunists, you see, are both right and left, and to try to give you a very bird's eye summary of it, I mean a very oversimplified version. It might very well be that the opportunists on the right, they'd say they find things that they want to and find other things they want to. They would find the 10th Amendment, and they would find the provision that forbids states from impairing the obligations of contracts. They would certainly find the takings clause, as it were. They would find a cluster of clauses that emphasize an interest in the protection of property, freedom of contract, open markets, things of that kind. Fair enough? And they would ring for them for all they're worth, in fact, considerably more, and rather pass over other parts of the text, as though somewhat apologetically. The opportunists of the left do not pay much attention to those particular amendments. They're very keen about the Equal Protection Clause. They speak of the, quote, magnificent ambiguity of the Equal Protection Clause. Magnificent ambiguity indeed, for it permits almost reading anything into it. Very keen about the 9th Amendment. What's that? Well, that's the one that suggests that not all rights enumerated are necessarily all that there are, and therefore you can expand upon that enormously. So they may even be somewhat enamored of the provision in the original Constitution that's not often taught. It's a provision in Article 4 that the United States shall guarantee to each state a republican form of government, and they don't have in mind the party. They have in mind the idea of expanding on what it means to have a republican form of government. So it leads to expanding the right to vote, minority participation, entitlements, and a variety of other things. It's as though you could take selective clauses and then by reading them with a great muscular vigor, if not violence, you see, then make that the kind of document which authorizes that which you think ought to be authorized and forbids that which you think ought to be forbidden by those muscular efforts of selective reading. On the right and the left, I've superimposed this Constitution on top, and you'll notice, incidentally, the perfect left and the perfect right Constitution are not mutually exclusive. They can agree on some things. I mean, some measure of freedom of speech is approved by both groups. Some measure of voting participation is surely approved by both groups. Some authority in the national government to command the field of foreign relations and not have 50 states with their various state departments cuts across ideological lines. So there is an overlap. The one I've superimposed is, quote, this Constitution, and it isn't perfect either right or left. As a matter of fact, it may have very great shortcomings depending entirely upon your point of view. I've emphasized the word this, however, partly because, as you know, now open one of the documents, that's this little Constitution. When you actually read the Article 6 provision as to what oath the judges take, the oath is to support and defend this Constitution. It isn't even the Constitution. Very interesting. It's this Constitution, as it were. Not the Constitution of your dreams. not the Constitution that John Rawls would have written, even if it be the case that John Rawls is a greater philosophic mind than those who composed this less adequate document, any more than it was the Constitution of Niccolo Machiavelli or any other great figure. So there is in the middle then, and the obligationists will not necessarily agree, but they are identified by this common theme. And that is that as judges, their oath is to support this Constitution, not some other. Not to misread it, not to overread it, not to read into their preferences or philosophic preferences, not to make it living by the superimposition of fashionable theory, regardless of the intellectual elite that may be developing it or to whom it may most appeal, but to leave that indeed to the other process of a living Constitution, the amendment process. So at the bottom, and then we're going to illustrate all these points, so this is less abstruse than this preliminary presentation. I've given you alternative processes of growth and of change. Remember, our title was Clashing Visions of a, quote, living Constitution. Great. Some critics have said, sour people, that wherever you see a judge or an author speak of the living Constitution, you can be pretty certain that the next sentence is a misrepresentation of the Constitution. It's setting you up to accept mendacity on the installment plan. I'm not inclined to do that. I don't think that's true. I think this is a very scrupulous effort in order to keep the document from being ossified and petrified. But that even as is happening with the interviews of these judges before the Senate committee, there is this premise at any rate that that's the task of the Supreme Court judges, to update it, as it were, by construction, by misreading or rereading or differently reading various clauses of authorization, separation of powers, and restriction. But there is another way of testing whether it's something living. And at the end, I've given you two comparisons which have struck me as just right. One is taken from my home state. It may seem vague to you. I'm going to explain it. One way of determining whether you have a living Constitution is this way. It's by looking to see whether there are any amendments, when they were made, by whom they were made, what is their content, what do they register, what do they tell you about the change that has taken place in the society to such a fundamental extent that it has now become a part of the fundamental law. So the comparison, the metaphor is the visible cambium rings of Sequoia sempervirens. Wow, what's that? Sequoia sempervirens is a phrase that means, Sequoia is a name, of course, of an Indian out on the West Coast. Sempervirens, Latin for always living. These are the great northern redwood forests in my home state, up above Mendocino and Humboldt and Trinity and Shasta County. They grow to a height of 360 feet. They live to an age of 3,500 years. 3,500 years. Second oldest living things on Earth. Wow. Won't tell you the oldest. Second. Bristlecone pines, David, are older. Every once in a while, because giant as these trees are, their root systems are quite shallow, so they have no deep taproot. Gigantic as they are, therefore, even though they're now carefully preserved in these magnificent cathedral-like groves, in heavy rains and after long droughts, one will fall. And occasionally a forester will cut across the massive face of it. And then you see all these cambium rings, which you learned of in junior high school. There's those little growth rings that are added annually, as it were. And you look across the face of that and you'll see a ring about this far, and it's 1776. Back here it's Columbus, and back here it's the Norman invasion, and back here it's the birth of Christ, and back here it's the birth of Confucius. And you are really awestruck that these things are still alive and recording those changes. Inside the cambium ring, you'll find a different chemical composition that kind of reflects the environment as of the date that the chemistry was integrated with that ring. Those are living trees. Other trees, once they fall, cannot add cambium rings. They petrify. Or to give you a different metaphor, they're like the Dead Sea Scrolls. That is to say, this is Holy Writ. And God, having inscribed on these scrolls His word, disappeared, and we will not hear from him again. So that necessarily then puts it to the task of very learned and capable rabbis to keep the meaningfulness of those scrolls alive by interpretation, for they have no choice. But they are Dead Sea Scrolls. The petrified tree is dead as it can be. It cannot add anything new. It is not alive at all. It's fiction. And that's the other metaphor which has occurred to me, and that's Hans Christian Andersen's fable of the emperor's new clothes. That is to say, the Constitution does not reflect an amendment, but the judges and the people say it is there. It is there. And by this congenial fiction, for they find that which is authorized, that which they wanted to find authorized, what they want to find prohibited, is also prohibited. Right? Every once in a while, a small child will look up and say, "Where? I don't see it. I just see underwear." Right. I don't see the raiment that you have ascribed to the emperor. It's a very interesting comparison. And that has often occurred to me. One thing that has occurred to me, too, is this. Cambium rings have become increasingly difficult to add to this Constitution. They've become increasingly difficult, in part, in my own experience, because people now mistrust the addition of new language, of anything other than trivial amendments. Whereas if you look back at the beginning, when Madison is proposing 12 amendments, actually an original list, I think, of 24, but they boiled it down, there is a degree of criticism, skepticism, certainly disagreement on the meaning. But if you look at the phraseology of the First Amendment, of the Fourth Amendment, Fifth Amendment, there's certainly room for uncertainty, if not consternation. There is no doubt in my mind that no amendment similarly framed could even successfully be proposed in Congress, much less would it be ratified. And that is because there is now a complete skepticism about anything significant by way of anything less than very precise words. There is now an almost fierce, inveterate, instinctive mistrust in amendments, because it may just give the judges and others a new palladium of radical license. To use the new language is still an additional springboard, right, for a form of constitutional heresy which may be pleasing to the new transient majorities, but was not at all involved in the original proposal. This has produced, in my own thinking, in all seriousness, a deadening phenomenon, and I would call it the negative synergy of licentious developments in American constitutional law. The negative synergy usually is the operation of forces cooperatively produce new elements not capable of being produced by either in isolation. The negative synergy is very clear. The more the courts do not require amendments in order to transform basic principles in American constitutional law, they do not require it as a new platform, the less necessary they seem to become. To the extent that they don't require it, and then to the extent that someone proposes suitable text to record a definite change and confidence and optimism in the fair administration of that change, the lesser the willingness of both Congress and the public to accept processes of change by meaningful amendments. It's negative because then as amendments become increasingly unfeasible, not just because the methodology of Article 5 is meant to be challenging. Of course, it's meant to require supermajorities, otherwise amendments would be like legislation, mere majoritarian products. It becomes increasingly hard de facto to meet the requirements of Article 5 to a much greater degree than was true 80 years ago, 100 years ago, 120 years ago. Exactly in such a measure as that becomes increasingly true, then even the more conscientious judges will feel under renewed pressure to allow innovative interpretations into older clauses because they despair of the amendment process. And so it goes. It just becomes a kind of endless cycle. Now, and then we'll get to the burden of one illustration of all this in less than 2 minutes. The burden of this came home with me now about 20 years ago. 1972, whopping supermajorities in both houses of Congress proposed the 27th Amendment. No, not the one you're going to read in here. In fact, most of you won't have the faintest idea what the 27th Amendment said. 27th Amendment was the Equal Rights Amendment. It simply says that neither the United States nor any state shall make or enforce any law, shall deny equality of rights under law on account of sex. Section 2, Congress shall have authority to enforce the provision of this article by appropriate legislation. That was it. Fair enough? Much more than two-thirds majorities in both houses embraced that proposition. Within 2.5 years, it had achieved ratification in 34 states. And if you're attentive to numbers, it only requires 38 to become part of the Constitution. Its progress then slowed. It slowed partly because of determined and fierce and very capable opposition, led in a variety of circles, most formidably by a very capable woman, Phyllis Schlafly of the Eagle Forum, who was against it, Root Branch, and by others. At the margin, it fell even with an extended deadline. Originally, Congress put it out for 7 years and then put it out for 3 more. It failed. It fell a little short. It lacked ratification. It came before the legislature of North Carolina 3 times, really, over a period of 3 years. It met biennially, and that was it. On one occasion, it came within 1 vote of 1 house of passing. Very interesting. It virtually carried. I was reliably informed that had it carried in North Carolina, then fence-sitting legislators in Florida would have voted yes, and it would have carried Florida. It needed those states and review in Illinois, Phyllis Schlafly's home state, where there had been a majority of the legislators for it, but they had a very odd state constitutional provision, which was itself unconstitutional, but that had to be shown. There was a provision in the state constitution that said ratifications of amendments to the national constitution shall be deemed valid if but only if they carry 3/5 of the legislature, not a simple majority. Fair enough? And they fell a little bit short of that rule, though they had a majority. Now, I don't want to extend this, but it was very clear to my satisfaction on the merits that after you counted for everything else on the pros and cons of the Equal Rights Amendment, about whether or not the potty problem had to do with sex-segregated restrooms. There was a foxhole problem, women in combat, and so on. The sponsor had all addressed these things. It said, I assure you, I have to take my word, eminently reasonable things about them. But there was skepticism and disbelief. And Professor Phyllis Schlafly was able to make convincing observations that in similar circumstances, the Supreme Court had taken the language and the understanding associated with earlier provision of the Constitution and just ignored the earlier understandings, as it were, gone right on its progressive way in order to fulfill what most people want from the Constitution. And therefore, amendments are no longer trustworthy. Vote for this amendment, and the next thing you know, there'll be women in foxholes, unisex bathrooms, and gay lesbian marriage. That was it. So it fell short. Now, you say, who cares? Well, I care a lot, actually. The 27th Amendment would have recorded a rite of passage, an R-I-T-E of passage, in a mature country that had come to differently to think about gender equality, gender roles. And it would have recorded on the face of this aging document, right, exactly what you want, a date recording a consensus, a change in a principle. What we have instead are a series of brokered Supreme Court cases. You can't find anything in the Constitution that attests to equality of right without regard to sex or gender. It's not there. In fact, the only provision that speaks to it goes the other way. It's a provision in the 14th Amendment that insofar as states deny men over the age of 21 and not previously convicted of a crime of the right to vote, then that state's representation shall be reduced in Congress. But the clause itself, therefore, you see, is a textual express recognition that the perpetual disfranchisement of women as such is consistent with equal protection and with the Constitution. It took with the 19th Amendment to change that. Fair enough? It did. And I want to turn to that before finally turning to one case to illustrate all that I've tried to say to you. At the end of this other handout, the last page, not the in-between pages, this is a very short chart, But I was put in mind, I added this late in preparing this lecture for the following reason. I'd just been reading Stephen Breyer's provocative book on, what's the name of it? The Active Liberty. Right. It's his effort to contribute to a school of jurisprudence in constitutional review, as a matter of fact. And I'm not going to review the book, but it struck me that he, again, as just happened thoughtlessly to many, said, you realize, don't you, that women were denied the right to vote until 1920 and the 19th Amendment, that women did not have the right to vote until then. It appears in his book. It annoyed me even when I saw it in the book by Stephen Breyer. He said, it's not just careless, but if you thought about it for a minute, that can't possibly be so. It can't be the case that women were denied the right to vote until 1920, because if they were, then the 19th Amendment couldn't possibly have gotten ratified. Since it takes 2/3 of both houses and 3/4 of all the states, if no state allowed women to vote as of that date, how many states would you expect to go along with this proposal? So it's just worthwhile looking back. And I thought, let's look it up, actually. And this related to my lecture. You know, it's very interesting, right? Wyoming, it didn't become a state till 1890, but even as a territory, it had a territorial government under act of Congress. So in 1869, women acquired the right to vote. Then Utah, wow, what? Mormon land allowing women to vote? Well, maybe because they could be controlled, who knows? But they did, and they never looked back. Then you look at the litany of states. You understand? By the time you get to the date that the 19th Amendment is proposed in Congress, you'll notice a majority of the states have enfranchised women. And the thought that if only men have the ballot, they're never going to give it to women, wrong. Maybe they gave it to them because they were threatened in the wonderful way of Aristophanes and Lysistrata. But who knows? That's a different story, and it's not my story. But that's very interesting because, you see, this is the cultural, political, legislative prologue to a Cambium ring, to the 19th Amendment. You see these cultural changes first reflected in the lesser Cambium rings of state legislation and state constitution. They report an evolution or development in the sociology and the culture and the politics and the generosity of the polity. And then it is recorded in the 19th, and there it is. Now we do not worry about whether the next judge appointed to the Supreme Court will, quote, overrule the decision that enfranchised women. There is no such discussion. Am I playing with you? So it is with these other things. Now, instead of this being the 27th Amendment, which I very much regret we do not have, even though the law is about the same as it would be if that amendment had been adopted, by a combination of legislative generosity plus judicial hubris. That's manipulating the language of the 14th and 5th Amendments in a way which would have dumbfounded the women's suffragette movement itself at the time. Instead, if you look at the 27th Amendment, it's a completely meaningless amendment, right, of the most doubtful pedigree. It was the Second Amendment proposed in 1789. The Second Amendment proposed in 1789. It has to do with members in Congress raising their own pay. Right. It didn't get enough votes in 1789 to become part of the Bill of Rights. So in fact, what you may think of as the First Amendment is actually the original Third Amendment of the series. The first two didn't get majorities. It didn't get enough majorities, and then in 1870, one other state ratified it. And then about 1970, some other states. And then it became very fashionable. So counting from 1789, by the time we got to 1994, 1992, you could get up to 38. And then it was added by the government printing office. Right. I assure you, if you took a Gallup poll of Americans with a high school, maybe and a college education, and you asked them how many of them could even identify the content of the 27th Amendment, not 1 in 1,000 could do it, and that's a high number, which would indicate it has almost nothing to do with being approved by significant majorities among living people. It just crept through, inch by inch, in this stealthy and meaningless way. There it is a doubtful Cambium ring, of no great significance. Now to an illustration of this finally. I want to take a case, a hypothetical, and have you think about it. Don't turn these pages yet. Don't you dare. And this is it. And this comes also from an experience when visiting at Chicago, as I was telling Professor Currie earlier, from an experience with a colleague of his, quite a famous man, Hans Zeisel, who with Harry Calvin at Chicago did some very seminal studies on jury trials. I want to propose an act in Congress with you. This is an act in Congress that will reduce the size of criminal trials in federal courts, criminal trial juries in federal courts, from 12, which has been the number since 1789, and indeed goes pretty far back to most of the colonies, and they reduce it to 7. That's my proposal. Why do it? Well, for one reason, it's a good economy measure, and I'm serious about that. Impaneling juries costs money, as a matter of fact, particularly with voir dire and jury profiles and all the rest. So you can save considerable money by reducing the size of the jury. It may be also that you may marginally be able to increase the rate of conviction, because if you have less of a chance of a holdout, let's say, if the defendant, as you may know, can get even 1 out of 12, at least the defendant avoids conviction. And while that's not as good as an acquittal, it's better than the alternative. So looked at from the defendant's point of view, you see, the odds of 1 out of 12 seem better. If you might be for this legislation, it might be in part because you think there are too many holdouts. It's not right, as a matter of fact. And indeed, in that respect, you could affect a secondary economy because it would increase the degree of plea bargaining, to the extent then that one has a slightly heightened expectation of being convicted, other things being held equal, just because the jury size will not be as cross-sectional or as numerous as otherwise. So you might be enthusiastic. These are good law enforcement reasons. If you like to serve them up in a politically divisive manner, attribute these to a despised figure, we'll make this part of the Nixon plan in the 1972s. But I wouldn't, because others might agree to reduce the size of the jury, though they don't agree with that analysis, as a matter of fact. In fact, they might say, the holdout problem you misunderstood. Sociological studies show that it's far easier for 1 out of 7 to hold out than it is for 1 out of 12. For it's only human nature to tend to want to succumb to the larger number, the larger that number is, and the fewer the number who side with us. So it's a self-respecting liberal could also vote for this measure, fair enough, finding it quite neutral in that regard, in terms of the equipoise between prosecution and accused, and the balance is economy, and so it goes. Never mind, grant me the hypothesis, and that's the act of Congress. They enacted, of course, under the necessary and proper clause, linked with their power to aid the judiciary in the performance of the judicial functions, as it's described in Article 3. Fair enough? Great. Now I hypothesize a case and want to include you in this exercise. And that is to suppose the President signed it, this has become law, a felony case is called in a federal district court. Defense counsel objects when there's an effort to impanel only a jury of 7. Fair enough? And the federal district judge agrees with the objection by saying, I have concluded that this is beyond the power of Congress to do. They have no authority to do it. In fact, I read it, the Constitution having forbidden them to do it. The government refuses to proceed. It takes a dismissal of the indictment, but an appeal from the judgment. It goes for the Court of Appeals, which passes it on. Supreme Court grants cert. Right. How do you go about analyzing the case, and what result and why? Let's say, what shall we do with this case? And I invite you, how do you answer it? What are you going to look at? Anybody want to start fingering a document? Do you want to start looking things up? Are you nervous as to whether or not there might be a provision that says a jury of 12 persons? If there is such a provision, is it going to bother you? Let's work a little bit. Let's work a little bit. The best known provision on the right to trial by jury is in the Sixth Amendment. Is it not? It's in the Bill of Rights. Here it is. So it says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. Stop. Great. You're the judge. You're the academic. Does that require a 12-person jury or not? Anybody can volunteer. Does Congress have the latitude to make a jury of 7 rather than 12? If it does it have the latitude to make a jury of 3 rather than of 7 or of 12? As long as it designates as a jury a kind of lay person drawn from the body politic as distinct from a trained judge, which would seem to be the kind of minimal distinction required by any dictionary amenities at all, is it within the discretion of Congress or not? Or at least are you uneasy about it? If you are uneasy, where are you going to turn to help you unravel the answer? Fair enough? Now, you might be, and this will not take long, you might look at this as a functionalist. You might say, well, the text is not clear. It is not dispositive. If it were, I would yield, and we needn't have much more debate about it. When the text says the president must be 35 years of age when elected in order to be eligible for election, we will not cavil even if we think it's rather antiquarian, and you could say, well, that's just a synecdoche, a stand-in figure for adequately mature. And we regard some people as adequately mature at 20 and others not at all, ever. Right. But we won't cavil because sometimes text is at least so explicit. But it's not here. It just says impartial jury. Right. If you're a functionalist and a law and order functionalist, will portray you in an unfair way as a right-winger. Too many people are going free. The justice system costs too much money. And anyway, the English have damn near abolished even the criminal jury. And they have. There are very few criminal trials, except for major cases in England. And the jury system's almost gone. In fact, that's where Warren Burger, as Chief Justice, became enamored of this whole trend. So if you're a functionalist, you might say, I think it would improve because crime is high. Federal courts are glutted. Costs are running amok. The tendency of defense counsel to employ specialized experts on jury profiling and voir dire is corrupting the system. And this would be a mildly salutary development. Thus, insofar as this result is not precluded by the face of the text, I'm for it. I'm for it. If you're on the other side and you thought, I don't think that's true about too many criminals going free. In fact, I think the technique of inducing guilty pleas has stuffed our prisons to such an absurd extent of semi-coerced convictions in this country that it is a national shame, and I don't, as a judge, will never vote to uphold this law. This is functionalism, as it were. It's how you want to read it on the outside. You're not trying to come to terms with anything here. You could start all over and say, well, it requires the jury to be impartial, but it doesn't say anything else. So we'll apply a maxim. Expressio unius, exclusio alterius est. What? Here in Durham, we speak of little else. The specification of some things excludes the consideration of other things. Fair enough, great. But are you inclined to do any work at all? Would you want to see what anybody said? Would it be of interest to you to know did this question arise when this provision was under consideration? Do you care to know what was said if it did arise? What if there happened to be solid agreement, one way or the other, as to what it meant? Do you think that would inform the words of this Constitution, or do you think, well, that's just what they said? You understand? But if you don't care about what they said was the meaning to be attributed to these words, then you're not construing this Constitution. You're simply making up your own without amendment. So I've given you a contemporaneous understanding on the first page. This is a speech by Madison. This is, and unlike the original Constitution, when the House met in 1789 in its very first session, the Philadelphia Convention was held, as you may know, in closed session. But in the House, not in the Senate, the House met publicly. There were notes. Madison introduces these amendments. Questions are raised. I've now given to you an attributed speech from the principal author of the Sixth Amendment itself, and there it is. I won't read it all, but I'll read the part. It says, commonly today such juries do consist of 12 persons. It is not intended, however, that number be mandated by this provision, assuming only that the stipulated requirement of ensuring its impartiality is scrupulously met. In brief, while it's to be expected that the tradition of 12-person jury will likely be reflected when Congress acts under the appropriate provision, setting the size of federal juries, it shall nonetheless be a matter within its sound discretion, not a matter frozen into the Constitution. That's it. That's the whole speech. And I suppose that some disliked it, but they understood it. And that was the understanding. Now the question comes back. That's it. That's what your research, maybe some of you didn't even care to do the research, in which case you don't really care about this Constitution. You're the opportunist, you're not the obligationist. But if this is all you came up with, and this was it, then it may be that for many of you, moi included, gee, that's disappointing. I wish that weren't the case. But it seems so clear that it seems to me, as a judge, it would be quite inappropriate to take an oath to support and defend this Constitution. Then when this issue comes up, and Congress has acted in this way, and this is the nearest thing we have to a dispositive record, say, well, that may be what Madison said, and that may be what other members of the House understood him to say, and it's true there is no such requirement, but that's not a very liberal or generous view, and I'm not going to be bound by that. I'm going to do the generous thing. Not at all. That's one scenario. But it happens that never happened. There is no such record from 1780. It doesn't exist. I only did it in order to sober you up and ask whether you care. Does it make any difference to you? Because we're in the business of separating the opportunists from the obligationists, and the work of constitutional law and of constitutional scholarship and adjudication. In fact, and here's part two, and this is what partly got Hans Zeisel really steamed. The Sixth Amendment is not the only mention of the right to trial by jury. And it is flatly true that most of the materials accompanying the Sixth Amendment, both when it's being discussed in Congress in 1789, and then briefly in the few state legislatures where it is taken up and drawn into some question in the 2 years of the ratification period. Very spotty records in most jurisdictions, rather generous records out of Virginia and one or two other places. Nothing is said about this on the size of the jury, at least nothing very definite. Maybe because this isn't the only provision on the jury trial. So friends, turn with me in Hugo Black fashion back to Article 3 on page 10. Then looking over at page 11, Article 3 is on the judicial power. Article 3 is on trials. Article 3 is on cases and controversies. So here we are. The trial of all crimes except in cases of impeachment shall be by jury, and it goes on. Wow. And you think, gee, that's interesting. How come they enacted a Sixth Amendment when we already had a provision back in Article 3 that already provided for a right to trial by jury? In fact, it's amazing because very few rights against the national government are articulated in the main body of the original Constitution at all. A few in Article 1, Section 9, ex post facto, bills of attainder, and then mostly in the Bill of Rights. But here it is. And you say, well, gee, that's interesting. I wonder whether this topic came up when that provision was being discussed, which might explain why it didn't come up again very much when the Sixth Amendment was being discussed. Am I clear? Now, nothing in Article 3 also expressly answers the question on the surface. It just says trial by jury. It doesn't say 12, 7, 3, or 1, or whatever size Congress shall appoint. But there are differences as you look. The Sixth Amendment made some changes, did it not? Indeed, for one thing, it will be a public trial, and Article 3 didn't say anything about that. Maybe because when Article 3 is under discussion, they did not provide for it, and when the question came up, the answer was very mixed. It was not clear that whether public trials would be public had not really been that firmly settled in the common law. Well, my time is running over, and I'm going to speed through the rest of this. Suppose, however, the topic did come up in the Article 3 discussion. And so now you turn to the second page. And that's a discussion that took place in the Virginia Convention, the Ratification Convention. And by God, friends, this is not an exact quote. I'm paraphrasing. There's a little liberty with the text. But this is a close approximation of a conversation that did take place in Virginia, where there were the most detailed discussions in the Constitution of any that we have recorded. It came up because people like George Mason and Patrick Henry were deeply skeptical about the new powers to be given Congress in the new Constitution. And when they looked at the right to trial by jury, in Article 3, they were skeptical that it didn't promise enough. And one of the questions they wanted to know was, well, does that mean they can convict on a mere preponderance of evidence? A different issue? Or must it be beyond reasonable doubt? Does it mean a jury of 12, or could it be a jury of less than that? They're very skeptical. They want nothing to do with this. So it is not provided for as it is in our Constitution, namely the Virginia document. Madison says, you're incorrect. This term is understood as a, quote, technical term. That's his term, not mine. It's a technical term. It draws, therefore, in its train all of the normal incidents as they are reflected in that book which every member has, Blackstone's Commentaries on the Common Law. The 12-person jury had then been in existence for something like 2 centuries. To be sure, it's later denigrated by Warren Burger as merely dating from the 14th century, which seemed to be an incredible oxymoron, merely dated from the 14th century. So he says you are mistaken. As to other things, they were not mistaken. And so the Sixth Amendment makes some changes. Didn't make any change here. Why? Because apparently of an understanding. Now, we come back to the year 2005. Suppose that to be the case. You're either an academic, you're a right-wing academic, you're a left-wing academic. You're a left-wing judge, a right-wing judge. Right. Do you care that that material is there, or do you not care? Do you want to say, I don't want to read this historical material? And in many cases, I don't want to read it because I think it's going to be disappointing. I'm fearful that it'll be like the first handout that I gave you, the apocryphal thing. And so it's better that we disparage the uses of contemporaneous history, because our feeling is that these were more narrow-minded, parochial, shriveled people. And while it may have been a comparatively able document for its era, it is not ours. So I fear to look at history for fear that if I looked at it, it will be disappointing, but I'll deem myself controlled. And so we don't look at it. Right. But if you did look at it, then you might say, my God, they were rather generous about this. 12-person jury is fixed. That's it. Don't tell us about economy. If you want something less than that, go amend the document. Fair enough. I've given you a third position, and then we're drawing this to a close. Because to a certain extent, the example I've given you is a real one. I hope it works. I hope it lets you know that as you think about this and think about who goes on the court, who writes about constitutional law, what approach you take to this subject, there is a function to be performed by judges who take it as their obligation to enforce this Constitution, not something different. And that includes its warts, such as you may think them to be, until those warts have been carved away and replaced. And all of the changes since. Fair enough. That's what judges should be doing as obligationists. And that's what professional constitutional scholars should do. And indeed, that is precisely why I have admired and cherished David Currie above all commentators, because his work is just rigorously scrupulous, and because one unfailingly learns in terms of the subtle and deft uses he has. Far more subtle than these throwaway examples that I've shared with you out of the Sixth Amendment in Article 3. Finally, to close, there is this third possibility, and on your own time, I welcome you to look at it. And that is to assume that you've done your homework as a conscientious person, academic, lawyer, judge. And you're quite in equipoise, because the material just isn't as definite as either one of these scenarios would have had it. That's true, of course, of so many matters that do come before the court, that after one has done this work, it is still quite uncertain as to what is the necessary result. Do you then immediately superimpose your vision from right or the left? Or do your best anyway to sort out from that which is available the most plausible consensus that you can derive from a very careful assessment of the larger field. In this case, assuming there were no debates, they were modest. They favored the 12-person jury, but assuming there were none, what other clues might you look for? One might be, what's the contemporary practice? Is it common, is it universal to have 12-person jury, or are they exceptional? How far back does it go? Is there something said in the Blackstone commentaries that tends to inform this, or not? There are a lot of other kinds of clues in the furniture or in the kit. Before you would finally decide, I think, this is really an open question. That say, there is really nothing here to tilt the balance. And yet, I'm not necessarily inclined just to yield as a deference to Congress, because surely, friends, there's absolutely no evidence that Congress ever did this work at all, or that its products were driven by this kind of genuine constitutional preoccupation, which is not theirs, it's social policy, but constitutional integrity. One last remark of this kind, and I'm finished. A very recent article, the author of which I can't now recall, tracked the extent to which Congress is conscientious in discussing constitutional issues and the extent to which it is not. One of the most interesting observations he had to share was sometimes it is, that is saying, and it even has the feeling they're really grappling and not just being rhetorical about it on the two sides. Often they're not at all. And what he noticed was the following, truly. Whether they do or do not correlates very closely with how seriously the Supreme Court does as well. Where the Supreme Court has tended to abdicate and, quote, defer, Congress not often even discusses constitutional points of law with any gravity at all. Where it is clear that the court is still active and concerned, as it has been the last dozen years in federalism at the margin, suddenly the discussions in Congress are revived. One can practically feel the beads of perspiration exuding from progressive foreheads, as it were. But that the Congress itself will take its own oath seriously to a very considerable extent, only to the extent that the court takes its oath correspondingly seriously. So between the two groups, I have no doubt that at least for those who are in the academy, right, it is the obligationists who care about the living Constitution that changes and reports progress through the doable ordeal of the amendment process, rather than the opposite. And my concern as I go to the twilight of my own academic career is that we have so far gotten accustomed to the exogenous Constitution that the amendment process begins to recede down a rabbit hole as in Alice in Wonderland, and the country is all the more pitiful on that account. At any rate, I count it a great joy to have David Currie and his family here, and thank you for your attention.
Thank you very much, Bill. I think you did prove my introduction suitable and correct, so I appreciate that. If I have my sense of schedule right, I think we only have a minute and a half before there's a new class that comes in here. So I will adjourn these proceedings, except for, and invite you to ask questions or make comments that you might have at the reception outside this room. But before you get up, let me just take this occasion to give something to Bill for him to take in his luggage on the way home that will help him to remember this experience and remember his time at Duke. You have your picture.
I see it.
So that will be this came with your 40-year thing. Thank you all for coming.